This is in reaction to what a number of former presidents of the Law Society of Kenya have ganged up, and they have come up with a move that would see the removal of each and every judge of the Supreme Court. Uh, I don't think that if they are successful, I don't think that they will have one tribunal for all of them. I think each judge of the Supreme Court will have an independent tribunal investigating him or her, because investigating them jointly is a big mountain to climb. And if they are all to be, if one tribunal happens for all of them at the same time, it will mean that all the charges, no, in such a tribunal, you only need to find the person guilty for one charge. Now, it will maybe a bit complicated, because if you are charging them together, maybe Chief Justice is found guilty of this charge, the deputy, whatever. So it will be each, that is my opinion before it starts. Each and every judge will have his or her own tribunal, independent, with secretariat, chairman, and members independent of each other, so that each and every tribunal does that. Another thing is, they have complained about all the judges. It may end up that facts may be found to set up a tribunal for one judge only, the rest be set free, or two, or three, or four, or even all of them. So when they are found that way, the first thing is, first of all, are there grounds? Yes, if there are grounds, are there grounds for how many judges? Maybe it is quite possible that one or two may be dropped from that initial stage. Then let's say four of them are taken to the tribunal. So we'll have four tribunals for each of the person found to have grounds. Then when the tribunals for the four, each should be given, you may even find that the judges, let's say the tribunal investigating judge so and so is different from the other. So you'll find that it will go on that way. So each and every judge will be handled independently. This one is also called impeachment. So the tribunal will continue, and as it continues, we have had that before. We had Justice Ojwang, where a tribunal was started, but by the time the tribunal was ending, he had already bypassed the retirement age. So he retired before the tribunal. You see, if the tribunal, if you retired yesterday and the tribunal finalizes its work today, it means that it has finalized its work when you are already retired. So that is what is happening. I wanted us to discuss everything, both over the table and under the table, to find out what is happening. Because when something like this happens, it has a lot of implications. And you see, it is a very big weight. If you are to do a tribunal for one judge, any judge, you remember there was a tribunal for the first Deputy Chief Justice, Justice Baraza, but it never ended because she offered to resign before time. So having so many, as I keep on reporting, saying, is that it is too big a food to be beaten. You cannot bite a big chunk of that. It is so concerning that a few months ago, if not weeks, Deputy Chief Justice Mwilu graduated with a master's degree in law. You see, to me, maybe it makes sense to everybody except me. But to me, I find it a bit hard because just take an example of Mwilu before she got her master's degree in law. She's a chief justice, and the lawyers who are appearing before her, she's the deputy chief justice, and the lawyers appearing before her are like Otienda Molo, who has a PhD in law. Just imagine. Or the deputy chief justice goes to a law school. She's being taught by law lecturers who also are lawyers and who may or do appear before courts. That was, I think, in the future we should get just lawyers who are PhD, all of them. We have so many. I mean, we should have justice, especially on the appeal court, but we should start with the Supreme Court so that all of them, anybody in future who is made a judge of the Supreme Court should have at least a PhD in law. That is my opinion. We know that during the last time when there was a Chief Justice, the person who was best suited would be Smokin Wanjala. But Maraga was taken deliberately. Maraga was taken deliberately with an aim. The aim of taking Maraga was to have him. Maraga is a very cool fellow. So Maraga is a very cool fellow, and they thought that it is somebody whom they could run around him. And that is why I also want to state here, please, if it is working, just leave it. And if it is not working, but if it is working, you may replace 1, 2, 3, or even all the judges and replace them with people whom you expect to be controlling, but you'll find that you'll have another Maraga. Those who undermined Smokin Wanjala and placed their Maraga, they did it with a belief that they did. If they would have known that Maraga would disqualify the 2017 election, they would not have placed him there. It also brought, I'm sure, maybe he has outlived it, but it also brought in anger and annoyance on the part of Smokin Wanjala. I think his morale is very low, and even when Maraga retired, Wanjala did not even attempt to apply for the Chief Justice work. I know you see that one is there. These judges are praising retired Chief Justice Evans Gesheru. Yet they are the same people who castigated him in the pre-2010 election. They made sure, you see, he was a Chief Justice then, and there is always this problem of making a law with somebody in mind. Imagine 100 years from today, hopefully, there'll still be that section of the law which mentions, I was checking the microphone, uh, there is that section that only talks about Evans Gishero. And it is written in just one line that the current Chief Justice, if he is interested in being a judge, he'll be a judge of the Court of Appeal. He'll not even be a judge. They deliberately blocked him. Maybe they would have even said that he should become the Chief Justice after the new constitution. But they said he's going to be a judge of the Court of Appeal, meaning that the constitution was deliberately made to make sure that he does not become a judge of the Supreme Court. It was deliberately made to make sure that he does not become a deputy chief justice, and it was deliberately made to make him not the chief justice. It would have just been made for him to smoothly. Now he's not there. We are praising. Even people who praise Kibaki. Okay, we remember those days they used to call him at mtu wako kiweta anakaa kwa wheelbarrow. That is how Kenya is. When you are in power, people disregard you. But in Kenya, it is uh, quite normal that when you are out of power, people praise you. But when you take, even if they praise you when you are out of power, and then you reach somewhere, and then gain power, they start saying, kumbe we were wrong, tuliambiwa. Uh, that is the problem with Kenya. Now that Evans Gishero is not there, we are praising him. But when he was there and is already old, we do that. It is also these judges, if I have to remember all of them one by one, I think uh, they'll be lucky if I would approve 3. Most of them have weaknesses here and there, but you see, we have not even solved the problem of the IEBC. And IEBC is a very important constitutional body that is going to determine the next election in 2027. We are now going to another very important body that is going to determine the 2027 election. It is really bad. And I would advise the president to be very careful with that. There are those people who surround him. They may try to tell him that they are doing it for his benefit, but it is not for his benefit, and most definitely, it is not for the benefit of the country. I've said a loophole, but then they are trying to make a super appeal, and that is wrong. If you look at the judges, when you start with Smoking Wanjala, you go to Njoki, you go to Lenaole, you go to Ouko. Those 4, Lenaole, Ouko, Njoki, and Wanjala, all of them are fit to be Chief Justice. If not, they are fit to be both. I mean, any of them can be a Chief Justice, any of them can be a Deputy Chief Justice. They are very good. And if there is there has to be a purge, maybe I would have a problem with Wanjala, Smoking Wanjala, for the simple reason that the way he performed in the 2017 presidential petition was bad. It was bad. One, if you have made a decision, you make a decision. 2, if anybody from a certain party annoys you, you don't change your mind because of spiting that. 3, you don't remember what they wronged you before, and then say, after all, they did take me to be a Chief Justice. Whatever happened between I'm forgetting my neighbor-in-law, Duale. What happened between Duale and Smoking Wanjala at this, what do you call this hotel in Upper Hill? Radisson Blue. That was bad. And it is also bad for whatever had happened for to have affected him. So I think he's not fit to be a Chief Justice. That one makes us now remain with Njoki can be a good one, Lenaole and Ouko. They can make, all the 3 can make good Deputy Chief Justices. All the 3 can make very good Chief Justices. You can take that one to the bank, and not the central bank, but the World Bank. Having said that, when you see lions, leopards, cheetah become friends, goats have got to be very careful. By this I mean, these people, if you look at them, apart from I'm forgetting the name of this senior counselor who used to Kuria. Yeah, I'll write the name in the comment. He has been very silent. He was very active and very powerful during Kibaki's time, but he has been Uhuru's time and even Ruto's time. He has been very quiet. But if you look at these senior judges, senior counsels who are previous former presidents of the Law Society, all of them are Kenya Kwanza leaning lawyers. They are Kenya Kwanza leaning lawyers. So I think I can say that this is a well-timed plan to replace the Supreme Court of Kenya with a new bench by 2027. Just understand that as much as it is very hard to constitute, you're constituting an IBC now. At the same time, you are constituting a new Supreme Court, and both of them are supposed to handle 2027. It is really bad if at all they'll succeed. And in this case, I said I can only vouch for 3 judges. I can only vouch for Lenaole, Njoki, and Ouko. Just as you saw the case of Radisson, smoking Wanjala is whatever. But then even with those ones, what I said is that if it works like a duck, quacks like a duck, then it is a duck. What I'm trying to say here is that all evidence of this appeal are only leaning towards the case of constituting a new bench for 2027. But let me tell you one thing, and if uh, history repeats itself, the reason why Maraga was placed there is that he was placed there as a Chief Justice for somebody who was perceived to be somebody whom you can control. Assuming, yes, that you remove the whole bench or even replace it with a friendly bench, and friendly I also include, you see, if this senior counsel, this thing is ni kupimana nguvu. They call it checks and balance, because if you let the judiciary to be very independent, then it becomes a judicial dictatorship. Like, I've seen a few cases of that nature. And if you, so there's got to be checks and balances. But then, especially a person like the Grand Mullah, Grand Mullah shares something to some extent with Joshua Miguna. These are the people who believe their way or the highway. And it is really bad for them to push for the new bench, if it will be there. They know who chased the other people. In Luya, they say, if you're a new bride and you get married to a man who is divorced, then try to find out why he chased the first wife. So if you replace that bench and with a bench, another bench, these people will only be looking there and say, I'll never differ with his former presidents of the Law Society of Kenya. So that is that. We have to do that. Even though the Supreme Court bench has also messed, you see, you cannot sit down as a judge in your own case and decide that people like Grand Mullah should not appear before your court. Him, like any other person, has a right to appear in any case, in any court, including the Supreme Court. And if you say that, you are reducing yourself to be like the Ugandan General Court Martial, uh, where Kiza, a lawyer called Aaron Kiza, was convicted by the bench that was there. It is really bad for the Supreme Court to pass a judgment denying Grand Mullah an opportunity to present himself before the Supreme Court or even any other, just like the Judge Advocate of Ugandan Court Martial say that it is not a must that you must have Aaron Kiza as your lawyer. You can look for any other, or you still have other among 30. If you tell Grand Mullah not to appear before you, it means that you are denying people out there the opportunity and chance to have a lawyer of their selection, who is the Grand Mullah, in case it is that way. That is how it is. Another thing I wanted to say, which is now not strictly about the Supreme Court, is that politicians fight other coalitions. Politicians fight other coalitions. But when their own coalition wins, then they turn against each other. We saw that in 2002 when they all ganged up and formed NAC. But once NAC came to power, they divided into two and turned themselves into each other in the absence of. Currently, I don't see anybody powerful enough to confront Ruto in the 2027. So you'll find that on Ruto's people, they are going to divide themselves into two or three other coalition now fighting each other. That is why you'll find that each and every syndicate is fighting for its own space. But generally, it is not a good idea and it should be shelved. I hope it is shelved because this is one arm of the judiciary that the what do you call, the bar is trying to control the bench. Thank you.